Let's see. Can everyone see me? I'm just trying to get you guys into the meeting now. You're locked in the waiting room. I'm going to admit you. There we go. There we go. All right. Now we're talking. Kenny's here. See Lauren. This is good. I don't know if you guys remember the romper room back in like the 60s and 70s. I'd say, look at the magic mirror. I see Lauren. I see Kenny. Good to see you all. Can you hear me?
Yeah.
Yep.
Awesome. We have 17 people. I think that includes me. I'm not sure. Oh, there's Hallie. I'm going to admit her. Okay. I think that's all of us. The whole class. No one's dropped out. That's good. No one's calling in from the hospital, I hope.
Mm-hmm.
Yeah, what an ordeal. I don't know what to say, guys. This is unprecedented. And I hope all of your lives are going relatively smoothly. I think we've mastered the technology part. I think we can do this. So I guess let's want to open up. I'm still struggling. I'm not struggling with the technology, but we're kind of learning it. I've been using Zoom for a while, but not in such a complex fashion. So you're gonna have to bear with me as I will bear with you. And let's see, I can mute all of you at once. Okay, that's powerful. And I can unmute you all. I wonder what happens if I unmute you all. I guess some of you are muted, seem to have control over your own mute. That's okay. I think the best practice is for everyone to stay muted. And I'll just leave it in your hands. I won't control it because I think I can, well, I can go, I guess I can, but why don't I let you guys control it and see how that works. So everyone mute their mic unless they want to talk. Now, how do we, yeah, I guess just unmute your mic because I'm not sure how to know if you're raising your hand. That's one thing I have yet to kind of figure out. If there's a way that you can tell me whether you have a question or not. Making a little note here. How to raise your virtual hand. But in the meantime, just unmute and interrupt me. I think we'll try that, and that should work well. Good, it looks like one more person. Hannah's coming in. Okay, we all are here. That's good. Yeah, so just interrupt me, I guess, as we go forward, and I'll take questions. I will try to conduct the class as we have been doing it, and call on each of you kind of randomly and have you read out the problem and take a first stab at it. And we'll proceed along those lines for as long as it makes sense. If it doesn't work, we'll try something else. But we might as well, go for the gold and try to keep things as normal as possible. Another challenge that I'm going to be working on is, as you know, when we're working through these priority problems, timelines help a lot. But I don't have a chalkboard or a whiteboard to do those on. There is a whiteboard through Zoom, but I'm just terrible at drawing on it. So it's totally illegible when I draw on it. It's my touchpad, so it's not like a chalkboard. So I'm figuring out the best way to handle that. It may be that I will type out the timelines beforehand and distribute them so that we can all kind of look at them together. That may be what I end up doing. But that's another thing that is a challenge to be tackled. Let's see. I have graded your midterms, And as a group, you've done very well. Proud, like a proud law professor. And so I'll share those grades with you today after class. And then on Wednesday, we'll go through and review the midterm before we go on to the next assignment. As far as grading goes, the faculty had a very long faculty meeting on Thursday, and we're going to have another one this coming Thursday. And we had a very vibrant debate about how best to handle the grading. And I think you'll be proud of me, as I'm proud of you. I have been the most outspoken champion of allowing you guys to choose after you get your grades whether you want to keep your grade or go pass fail with respect to that class. A number of professors think I'm being a little too generous, but why not? These are extraordinary times. It's time to be generous, take care of each other. So, but that hasn't been resolved yet. So you will know. I may know a few minutes before you, but we'll all find out about the same time, probably on Thursday. Okay. Any questions? Someone ask a question just so I can test this technology. You can ask me my favorite color or something.
I have a question.
Okay, good.
Can I bring my cat to class?
Yes, you may. Absolutely. No, I think that kind of frivolity would be helpful for all of us. So absolutely. Bring your cat, bring your kids, let them, learn about the wonders of secure transactions. Any other questions? That was perfect, and you came in loud and clear, and everyone heard her. Anyone has any problems, speak up, let me know. Otherwise, I'll assume the Zoom is operating. So let's see. Well, let's just dive into the material. And is Nate? I know you're here.
Here.
Where are you? There you are, Nate. Excellent. So why don't you do the honor of taking us through our first problem in this coronavirus age.
Sure.
Philip Philately. Philatelist is, as you know, a stamp collector.
All right, so this is problem 69 on page 170.
Exactly.
So Philip pledged his valuable stamp collection to the Collectors National Bank in return for a loan. He gave CNB an oral security interest in the collateral. No financing statement was filed. The bank put the stamp collection in its vault, and then Philip later borrowed money from his father, Philbert, and gave him a signed security agreement in the stamp collection. The father filed a financing statement in the proper place, and then answer these questions. Okay. Who has priority between CNB and the father? And then, okay, so I'll do that one first.
Take that one first. That's a good chunk.
So I said CNB because they have a perfected security interest just in possession of the stamps.
Yes, that's part of the answer. Yeah, they have a perfected security interest. That's true. But why do they beat CNB, the bank? They also, do they have what about a CNB? Do they have a perfected security interest?
Yes.
They do. They signed a security agreement, so it attached, and we assume all of it was sufficient, and then they filed a financing statement, which we assume was sufficient and in the right place. It says it was in the proper place. So they're perfected as well. So we've got two perfected secured parties, one by possession, one by filing. And you're right that CNB will win, but why does CNB win over his father? The father, I'm sorry if I confused that. Let me start over. So CNB has perfection by possession. They have the collection in their vault. The father the father is perfected because of the filing of the financing statement. But CNB wins. Why?
Is it because they had possession before the second agreement
That
or
is
filing?
true. That's true. I'd just like to put a finer point on that by saying that they were perfected before the father filed. They were perfected by possession. So yeah, you're right. They had possession before the father filed. And they perfected. So it's a first to file or perfect rule between two perfected secured parties. And here, the first to either file or perfect was CNB. They perfected first, taking possession. Good, good. All
Okay.
right. We're easing back to this stuff. All right, good.
Yeah.
Take it away.
So part B.
Yeah.
If Philip goes to the bank and takes the collection home so that he could add new stamps but does not return it, does the answer change? So I said yes, it probably could change, because when CNB loses possession, they are no longer perfected. I know there's a couple rules to this. For example, the time of possession or temporary perfection. So if they are doing it for a certain purpose and they return it within 20 days, they may retain perfection, but I don't think that's the case here.
Yeah, this is getting a little bit in the weeds. So we've looked at these situations before where you're allowed to take, for example, a promissory note or even goods from Bailey, who has them in their possession, but only for limited purposes, such as to present the note for payment or to service the goods to maintain their value and their condition. But here, it doesn't really fit those circumstances to add it, to take it, to add more stamps to the collection. That's dubious, and whether that's really necessary to maintain the value of the collection. The collection as it is was fine. There's no need to really add more stamps to it necessarily. And if you look at 312F, a perfected security interest in a negotiable document or goods in possession of a bailee, other than one who has issued a negotiable document, remains perfected for 20 days without filing. If the secured party makes available to the debtor the goods represent the goods for the purpose of sale of exchange, unloading, loading, manufacturing, processing, or otherwise dealing with them as a preliminary step to sale and exchange. Here we don't have it. It doesn't apply because we're not talking about a bailee, someone that's holding the goods for the secured party. So long and short of it is that we lose perfection here. This isn't one of those situations where you're allowed to have temporary, take away possession temporarily and then return it without harming the priority rights of the person in possession. That doesn't apply here. And so what happens is when Philip goes to the bank and takes the collection home, the bank loses its perfection. As soon as you give up possession, you lose your perfection. That's the general rule. And then when you get it back, yeah, you're perfected again, but only as of that date where you got it back. And so CNB gave up their possession, so they really lost their place in line. When they get it back, they will regain perfection, but then the contest will be between the father who filed and the bank that regained possession after the filing, and the father would win. So just remember that if you lose possession of the goods, then your you lose your place in line, I think is a good way to put it. You lose your perfection, and if you renew your possession, you'll be perfected, but only as of that moment. That'll be the date that you use for the priority contest. So don't give up your collateral. If they ask you if they can have it for a little while to do this or that, do not do it. You'll lose your place in line unless it falls into one of these narrow categories that we've talked about, where it's necessary to maintain the condition of it. Maybe you could argue that here, but I don't think so. I think that's an uphill argument. And 9.3.13d, we can look at that one too. That's the other rule that deals with temporary loss of perfection, or how to measure the time of perfection here. If perfection of a security interest depends upon possession of the collateral by the secured party, this is 3.13d. If perfection depends upon possession, perfection occurs no earlier than the time the secured party takes possession, and continues only while the secured party retains possession. So once you give it up, that's the general rule. Once you lose possession, you lose perfection. You can regain it, but you'll lose your place in line. All right. C, Nate.
So C. So we kind of started leading into C. So if C and B makes Philip sign a security agreement and then turns the collection over to him, but never files a financing statement, who wins? So I said the father would win, and C and B should have retained their possession of the collection.
All right, so C and B makes Philip sign a security, which is and turns the collection over to him, but never files a financing statement. Who wins? Okay, well, what?
So I also looked into Rule 9.308c, which states that.
Yeah, what does that tell us?
It says that a security interest is continuously perfected if you first filed with one method and then filed with another method.
Right, right, which means that if you say you take possession, and then so you're perfected by possession, and then you get a security agreement, you file a financing statement, now you're double perfected, and then you give up possession, you're good. Your perfection has continued, and the date of your perfection will relate back to when you were first perfected by possession. So you can initially perfect by possession, and then if you're tired of holding onto the goods, you can file a financing statement and give them back, and you'll still maintain your place in line. But did that happen here?
So no, because it says that they turn the collection over, but they never actually file a financing statement.
Yeah, so they lost.
They did it wrong.
They did it wrong. Yeah, they got the security agreement. That's good, but that's only half of what they had to do. They had to file a financing statement before handing the stamp collection back to Philip. They failed to do that. They were first to perfect, but then they lose their perfection, and therefore it becomes, at the end of the day, if you want to write a perfect exam answer, at the end of the day it becomes a contest between an unperfected secured party and a perfected secured party. And we all know that priority rule, perfected secured party wins. So they blew it. Good. Nate, you did really well with that. I know you had 3 weeks to prepare your answer, but I'm sure you would have done just as well had we had like 5 more minutes that day 3 weeks ago.
Exactly. I'm impressed you remembered.
You're probably very, very kind of sad I remembered, but no, I did. I made a little note, and I'll give you another check here. So you won't be on the hot seat for a little while.
Awesome.
All right. So now we're going into a new assignment. Any questions about that first? All right. Now we're starting a new assignment on purchase money security interest. And really, as I look at the I kind of marked up syllabus here, assignment 8, which we just finished, dealt with priority. And now we go on to purchase money security interests, but really this all the following assignments through I don't know 15 through assignment 15, they're all dealing with priority. They're just dealing with priority regarding various types of collateral and other situations like purchase money security interests, who has priority in those situations. Control and priority deals with priority dealing with those types of collateral that can be perfected by control, such as deposit accounts, bank accounts, and investment property. Buyers, who has priority when you have a buyer in the picture. 12 is fixtures, statutory lien holders and fixtures. That's a special type of collateral that is personal property, but then gets installed in a house, for example, and becomes real property. It's a fixture, and it's a special type of collateral with special priority rules. Accessions and commingling also is that situation where you have, there's a great, we'll get a lot, we'll be talking a lot about eggs and, was it eggs and flour and cake? The question will be, if someone has a security interest in eggs, another party has a security interest in flour, and then they bake a cake, who has a security interest in the cake and how much? And how do you divide that up? So that's another special type of situation. Proceeds, who has priority with respect to the proceeds of collateral? It's also a separate type of collateral. So we're not leaving priority behind as we go forward in the syllabus. This is kind of most of the rest of the course will be about priority issues. So that said, give you a 30,000 foot view of the course. Let's turn to assignment 9 and purchase money security interests. We've talked already about purchase money security interests, but we're going to talk some more about it. Just give me 1 second. I'll be right back. Everyone take a 2-minute break. I'm going to get some water.
Haley, what's your dog's name?
It's Zila.
Zila?
Yeah, she's trying really hard right now to be good. Hi, puppy. 1 second.
Oh, she's adorable.
She has little eyebrows. Oh, thank you. Oh, thank you.
Look at that. Cute pup.
Thanks, guys. Thanks, guys.
Okay. Now, another thing I'm working on with Zoom is sharing my screen so that we can, I do it in class. I bring the Cornell website up so we can all look at the UCC together. I'm still getting comfortable with that. I thought we'd try just to kind of break out our statutory supplements together, and we can kind of look at the statute. Makes it a little less technologically challenging for me, but I am going to try to improve my Zoom skills so that it is just a technological masterpiece by the end of the semester. So I'm going to work on that. And you guys can play with Zoom too. I hear there's a great way to put like any background you want. I had one at the faculty meeting. There was a faculty member that put like the Egyptian pyramids behind her. I thought, why is she in Egypt? How did that happen? But then I realized that afterwards, that I was for a little while. I was very confused. Okay, so where do we want to go? We want to go to 9-103. I guess is the first place, and we've looked at this. This is its own separate section, definitional section about purchase money security interests. We've read through this before, but I'll just direct it to you direct you to it again, but I think we've discussed in fairly clear detail about what a purchase money security interest is. It was actually, there are two flavors of it, right? The purchase price security interest, where you sell something on credit and take a security interest in that very thing that you sold. Or if there's the enabling loan, purchase money security interest, when you are a bank and you loan money for the explicit purpose of buying some specific goods. And then the money is actually used to buy those goods, and you take a security interest in those goods. And again, purchase money security interest only applies to goods and software, parenthetically. So don't think about PMSI if there's another type of collateral involved. Okay, so purchase money security interests. We've learned about them. I think I've hinted to you that they get super priority. It's an exalted place to be a purchase money secured party. And let's see. I want to look here. How about 324? The 324, 9324. These are the priority rules for a purchase money secured party. So this is what we'll be looking at. And let me just talk theoretically a little bit so you get a kind of a theoretical understanding of the need for purchase money secured party. We've talked about how a bank that has a security interest over all of the assets, let's say, of a company, and has a financing statement filed so that they have first priority. They have a security agreement that covers all future advances. That bank has a stranglehold over that customer. No other bank in its right mind would loan that customer any money, because it would know that it would lose in the event of bankruptcy to the other secured party, who's first in line. It's a stranglehold. Now, there's a couple ways you can beat it. Another bank could enter into an intercreditor agreement with the bank that has the first priority security interest, and they could work out in and amongst themselves. Hey, if there's bankruptcy, let me, the new bank, get $500,000 of the collateral, and then you can have the rest. Some kind of arrangement that makes sense. And parties can always do that, but only amongst themselves. If there's a third secured party out there, two parties can't get together and arbitrarily decide that they're going to carve up that third party security interest. But as to two people, you can decide that. That's fine. So that's one way to break the stranglehold. Another way is the purchase money security interest. And it allows a company to make purchases on credit and to allow that new secured party to have priority over that bank with the stranglehold. That's what purchase money security interest does. And so it releases the stranglehold. So that if a company has to, let's say it's a hardware store, if they need to buy inventory and they need to borrow money, they don't have the money to do it, but the bank won't loan them money or won't loan it to them at a reasonable interest rate, the one that has first priority. Now, without PMSI, they'd be in a very bad situation because no other bank is going to loan them money. But the PMSI allows them to call up a hammer manufacturer and say, hey, I want to buy 10,000 hammers on credit, and I'll get you a security agreement. You can file a financing statement, and that manufacturer will sell them to, will sell those hammers to the store because it knows that it will be a purchase money security interest and it will defeat that bank with the stranglehold. And so that is the beauty and the necessity and really the purpose why it was created, to allow companies, debtors, to escape the stranglehold and to make purchases. And there are two types of purchase money security interests now. Not the two types, the two initial types, purchase price and enabling loan. But now under 324, when you're talking about priority, there are two types. One is the purchase money security interest in equipment. When a company has to go out and buy like a new robot for its factory floor, or a new supercomputer. It can go and do that and buy it from IBM and give them a security interest, and they will be a purchase money secured party with respect to this new supercomputer, which is equipment. Now, what do you have to do in order to ensure you get that super priority? You have to do one thing, and that's in 9324A. So there's a perfected purchase money security interest in goods, other than inventory or livestock, has priority over a conflicting security interest in the same goods. I'm going to skip that line about proceeds. You will have a purchase money security interest will have priority over a conflicting security interest in the same goods if the purchase money security interest is perfected when the debtor receives possession of the collateral or within 20 days thereafter. So you will get your super priority as a PMSP, purchase money secured party, if you perfect your security interest within 20 days of delivery, which usually means filing a financing statement within 20 days of delivery. So as long as IBM, when they sell the company that supercomputer, files a financing statement within 20 days of it being delivered, then they will beat the bank with the stranglehold. So that's all you have to remember. First, you got to make sure it's a PMSI.
Good question.
Yeah, go ahead. Dominic.
So why do you have to do a filing statement if there's an automatic perfection right at attachment?
Ah, good question. Good question. I'm glad you brought that up, Tom. That's sharp. Normally, you file a financing statement. Maybe that's what I said. I think the better way to put it, Dom, is when the purchase money security interest involves non-consumer goods equipment. It's not consumer goods. So this factory robot, not consumer goods. You got to file a financing statement to perfect it. But you're right. If I am I'm an individual and I go to Best Buy and buy a widescreen TV and they take a security interest in it, that's a PMSI. And you're right, the PMSI in consumer goods, it's my personal use, PMSI in consumer goods is automatically perfected. So Best Buy is all set. They've been perfected within that 20 days. They were perfected immediately, automatically, so nothing further has to be done. And they will defeat any secured party that has a security interest in my goods. So good point. Does everyone follow that? Nice. So, yeah, speak up if anyone has a question. Just interrupt me. Well, it was well done. You set a good example there, Tom. That's the first type of purchase money security interest under 324, dealing with equipment. Or consumer goods, I guess it could be. Equipment or consumer goods. The second one is inventory. And that's under B. So when you're dealing with equipment or consumer goods, you have that 20-day grace period. It's pretty nice. It's not that hard to get your super priority. It's harder when you're dealing with inventory. For example, in that hammer scenario, the hardware store with the hammers. That's inventory. And there's a different rule if you want to enjoy your super priority, and I'll read through this here. Subject to subsection C, la la la. Perfected purchase money security interest in inventory has priority over a conflicting security interest in the same inventory. Okay, I'll skip the subsequent language there just for simplicity. Skip down to the if. So you'll have your super priority in inventory if I'm skipping down to the if at the very bottom of that paragraph, right before the colon. There's a lot in there that we're going to get to a little later regarding proceeds, but I just want to focus on this immediate question of the super priority. You'll get super priority as to inventory if, number one, the purchase money security interest is perfected when the debtor receives possession of the inventory. So you have to be perfected not within 20 days of delivery. You have to be perfected before delivery or on delivery, but it's usually before. And now we're talking about inventory, which is only going to be a company. And how do you perfect a security interest in inventory? There's only one way, a financing statement. I guess you could take possession of it, and with very high cost items, secured parties will take possession of inventory, and then they'll like put a fence around it and lock it up, and then every time the company sells $1 million supercomputer, they'll unlock it and let you take one out and deliver it. So it's possible to perfect a security interest in inventory by possession, but usually it doesn't work, right? They need to have the inventory in the store. So you file a financing statement is typical. So you want to file a financing statement before delivery takes place. 2, the purchase money secured party sends an authenticated notification to the holder of the conflicting security interest. Okay, so you have to send a notice to the holder of the conflicting security interest. Now go on here, it says the holder of the conflicting security interest has to receive the notification within 5 years before the debtor receives possession of the inventory. Don't worry so much about that 5-year rule. The important is that you have to receive the notice before delivery. And 4 is about the substance of that notice. The notification states that the person sending the notification has or expects to acquire a purchase money security interest in inventory of the debtor, and then describes that inventory. So there are 4 sections here, but there are really only 2 rules that you need to keep in mind. If you're that manufacturer selling hammers to the hardware store, you want to file a financing statement before the goods are delivered, and you want to send out a notice to everyone that has a security interest in the inventory of that hardware store. And in that notice, you want to say, hey, I am the hammer manufacturing company. I am delivering 10,000 hammers to Ace Hardware on such and such date, and will acquire a purchase money security interest in those hammers, period. Okay, so you're gonna put these people on notice. How do you know who has a conflicting security interest? Well, you just run a search on the Secretary of State website. You run a search and see if there are any financing statements. And then you look at those financing statements and see and read the description of collateral and see if it covers inventory. It might only cover equipment, then you don't have to send it to anyone. But if you find a financing statement that covers hammers or covers inventory or covers goods, because that would also include inventory, then you've got to send a notice to this to that secured party, and they have to receive it before delivery. So it's a little harder to get your super priority with respect to inventory, but not impossible. You just have to be careful you don't release the the goods that you're selling until you file a financing statement and send out those notices and allow time for them to be received. And once that happens, then you send out the truck and deliver the goods. And then you have super priority over those hammers, and the bank with a stranglehold can't get them. So keep that in mind. When you're dealing with equipment or consumer goods, all you have to do is, with consumer goods, you don't have to do anything because you're going to be automatically perfected. But with equipment, you got 20 days after delivery. File a financing statement and assure your super priority. With inventory, you got to file before delivery, and you got to send out those notices and have them received before delivery. Now, the 5-year rule says it has to be received within 5 years and before delivery. That's so that you don't send out this notice. Let's say I'm going to send, I'm going to start selling hammers to Ace Hardware, and I plan to do it for a long time. I can't send out a notice to the other creditors and say, hey, I'm going to be selling inventory, selling hammers to Ace Hardware for the next 20 years, and we'll have a purchase money security interest in it. That notice is only going to be good for 5 years. You got to send it, in order to be effective, you have to send it within 5 years. You know, because I think if you just send one and it lasts for 20 years, then it's likely that people will lose that notice. It'll get forgotten. And so we want them, it has to be within 5 years. So those other secured parties have some reasonable chance of remembering that the notice was given. But that's usually, you know, not a big issue, but something to be aware of. All right. So, yeah, let's stop there and ask if you guys have any thoughts or questions about that. Good, good. It's an important rule to learn, certainly tested with regularity on the bar exam. So it's important to recognize it, you know, not struggle with recognizing it, but really, you know, get in the habit of being able to recognize its purchase money security interests, and then get crystal clear in your mind the difference between equipment and inventory when you want to assure that you get your super priority. Okay, good. If there are no questions, then well, let's move on. And got a pen here. There it is. Right. How about Ashley? Ashley, I see you're there. Do you want to unmute yourself and take problem 72, the first of our PMSI problems about Paramount Homes?
Sure. Okay. When Paramount Homes finished building Utopia Limited, its newest fancy apartment complex, it had to furnish the clubhouse. So it sent its construction manager, Bill Gilbert, to Sophie's Interiors, a furniture store where he made $2,000 worth of credit purchases and signed a security agreement on behalf of Paramount Homes in favor of the seller. The agreement was signed on June 8. The goods were delivered the same day. Bill failed to mention that all his employer's equipment was designated as collateral on an existing security agreement and financing statement in favor of Sullivan National Bank. This agreement contained an after-acquired property clause, which stated that later similar collateral coming into the buyer's estate would automatically fall under the bank's security interest. The policy of Sophie's Interiors was not to file financing statements for its credit furniture sales. Why might it have such a policy, and is it wise here? So I thought that it probably had such a policy because of they probably usually sell to consumers for consumer goods because it's furniture. And so usually they wouldn't need to file a financing statement because it would automatically perfect.
You got
it. It's not wise here because it's going to be equipment for a business. So it would not automatically perfect, and they would need to file a financing statement if they wanted to have their super priority.
Exactly. We're dealing with equipment here. The couch is equipment. It's not for personal use, right? So it's not consumer goods. It's not automatically perfected. It's equipment. They had to file a financing statement. And so at the end of the day, what does the contest come down to, Ashley? If you could characterize the two parties at the end of the day, we have Sullivan National Bank, and then we have the furniture company. How would you characterize them?
Well, it seems like Sullivan National Bank, they have a perfected security interest, and the new creditor, Sophie's Interiors, is an unperfected secured party. Exactly.
It's not just that they lose, didn't file in time and don't have, super priority. They're not perfected at all. So it's really the rule. It doesn't even go to kind of 9-324. It's just a contest between a perfected versus an unperfected secured party, and the perfected party wins. Exactly right. Okay, B, on June 10th.
Which creditor will have priority in the furniture, and on June 30th? And I thought both dates, because there's no filing statement, that the bank would have priority because they have this after acquired clause on equipment, and they're of the perfected party.
Yeah, I guess my earlier answer may have been a little too flip, a little too neat, because I was taking a longer term view of it. But it's right. What happens if on June 10th, let's say the Paramount Homes goes bankrupt, and now Sophie Interiors wants those couches under its security interest, and Sullivan Banks wants them too.
Well, I mean, would it depend on if they filed a financing statement within 20 days?
Well, they have 20 days to do it, but the question is, what if there's bankruptcy before that 20-day grace period is over? I mean, let's say Sophie's Interiors was intending to file a financing statement and said, hey, we had 20 days to do that under the law. And now they went bankrupt suddenly. That's not fair that now we would be treated as an unperfected secured party. We have this grace period. And Sophie's Interiors would be right. They have this 20-day grace period. And so they're treated as if they have super priority. But that super priority will only last for 20 days, during which time they have to file a financing statement if they want to maintain their super priority. So if there's bankruptcy on June 10th, 2 days after, Sophie's will win. They will have their super priority. They have the 20-day grace period. But if there's bankruptcy on June 30th, who wins, Ashley?
The bank.
Bank wins, yeah. Now that grace period has expired. They didn't file a financing statement, so the bank wins. So, does that make sense? Okay. Well done. Please just speak up if you have a question. Otherwise, I'll just thank Ashley for doing a good job and go on to problem 73 about a video wonder. It's an odd problem, but instructive one. Where should we go? How about Lauren? Lauren, are you there?
Hi, I'm here.
Do you want to take this one, or are you sounding reluctant? I already sense in your voice.
Well, so I have a little bit of an issue. Maybe I should have mentioned something before class really started, but I actually don't have my books. They're currently in my locker at school, and I've been unable to get them because the school's been closed, but they are open today, so I do intend to go and get them like right after class.
Okay,
So,
all right. Good luck with that. Yeah,
I apologize.
I think these kind of issues, let's don't worry about it. But these are the things that are kind of unforeseen. These things that surprise us that we maybe don't think of. But yeah, if you've left anything in the law school, and we got an email. I don't know if you students got an email. Well, be sure to come down and get everything you need.
Yeah.
Because it's closing down. And but I don't know. I didn't go down and clear out my office, and there may be something there I will need. So I may be in a similar situation. So that's all right. You want to take a pass, or do you want to give it a shot?
I would probably like to pass just for right now, but if you want to call on me for next class, that's totally fine. I'm going to the school to get my books today, so
all right.
I'll have them. I apologize again.
I promise I will call on you again. No problem. All right. Well, let's go over to, I see Taylor only has 2 checks. So I feel bad about that. So Taylor, you want to take this on? Are you in the room? I think everyone's in the room. No lurking allowed. Maybe not. No Taylor? Okay.
Oh shit, shoot, I'm sorry. I didn't see I had the mute button on. Hi.
That's okay. No worries. All right. Yeah.
Okay, so.
So Video Wonder, problem 73. Go ahead and read it, and let's try to wrap our heads around.
Okay. Video Wonder, an electronics store, has granted a floating lien over its inventory and equipment to Last National Bank, which perfected its security interest by filing a financing statement in the appropriate place. Needing a guard dog for the video store, Video Wonder's manager responded to an ad in the newspaper placed by Agatha Shaw, who was selling her beloved German Shepherd, Fang. She had bought him for protection when he was but a pup, but he had proven too much for her, having seriously injured a meter reader and 2 mail carriers. She checked out the store carefully before agreeing to sell Video Wonder the dog, saying she wanted a good home for Fang. He cost the store $1,200. The manager agreed to send her $100 a month until the dog was paid for, at which time she agreed in writing to sign over Fang's papers. Mrs. Shaw and the manager agreed that the store would not get any title to Fang until all the payments had been made. Fang proved to be a fine watchdog for the store, but when Video Wonder stopped making payments to all creditors 2 months later, Last National Bank seized all of the store's assets, including Fang. Agatha Shaw is upset. She calls you her attorney. Is there any hope for her? Can she argue that the bank's security interest only attached to Video Wonder's equity in the dog, or that until Video Wonder had paid the entire debt, it had no property interest to which the bank's floating lien could attach?
Okay, this has a couple of kind of challenging concepts in there, but how did you manage?
So I looked to the 2 cases that they suggested.
Okay.
Because there really wasn't anything else to go on. The ITTV Reagan case, it was kind of about a mortgage company security interest. And that court found that the mortgage company's security interest was entitled to priority over a credit card company's purchase money security interest, only if the credit card company failed to protect within like the 10-day grace period provided by the statute. And then the second case held that the bank's security interest did not attach to the collateral because the third party did not fulfill the condition precedent to pay a down pay to the property owner. And there they found that the bank's security interest could not attach because the third party had mere possession. And that second case I found most helpful because it kind of was the same as here. They were making payments on the dog. Their interest couldn't attach because they technically didn't own the dog yet, and they really only had possession of the dog in the store. So I think that she does have a case to be able to, maybe get her dog back and do it that way.
Yeah, if a court finds that the store only had possession of the dog and didn't own it, had no rights in it whatsoever, well then then the answer would be easy. Then Ms. Shaw would get the dog. But is that the case? Did anyone else analyze the Ms. Shaw's rights differently? And the nature of the transaction that she entered into? This, she sold her dog on credit to the store, to the electronics store. And that she would, but the store would not acquire the dog until the full $1,200 was paid off. I think that's the import of, she won't sign over the papers, allowing transfer of ownership of the dog until the dog was paid for. How do we deal with transactions of that type? How are they characterized under Article 9?
Like where they're not haven't fully paid for it yet?
Yeah, you remember it's called a title reservation agreement or a conditional sales agreement, where you're going to hold on to title until all of the money is paid, all the purchase price is paid, and then transfer title. Does anyone remember what we do with that? Title reservation agreements. Title reservation agreements. All right. I will break the suspense. And remember that is another type of transaction that was used prior to Article 9. That's similar to having a secured transactions. You hold on to the goods until there's final payment, and then you deliver the goods. That does protect the seller. It gives them a protection similar to having a security interest, in that if there isn't final payment, you get the goods. But Article 9 will treat this as simply an outright sale, giving the electronics store title to the dog. An outright sale with the retention of a security interest. So even though Ms. Shaw thinks that she has title to the dog, owns the dog until the $1,200 is paid, in fact, the electronics store owns the dog. And Ms. Shaw only has a security interest in the dog in the event that there's a default in the payment obligation. So that's just something that Article 9 does. It changes the nature of this transaction. It isn't what it's purported to be. It's only going to be a sale with the retention of a security interest. So now, if we look at it that way, then we have Ms. Shaw as a secured party. Let's see. Yeah, and that installment sales agreement or whatever the sales agreement, whatever they had, that will serve as the security agreement. So what we have here is a secured party, Ms. Shaw, with a security interest in the dog that she sold the electronics store. Okay, and how would you classify the dog?
I mean, since its purpose was kind of to, protect the store, I think it has an argument it could be made for equipment.
It's equipment, that's right. Even though it's a living thing, it's equipment because it falls into that catch-all category. Right, so she has an unperfected security interest in the dog, which is equipment. And what about Last National Bank?
I mean, they lost the dog, but
let's see. They seized the store's assets, including Fang, and they want to have Fang now. Of course, it's a battle over who gets this dangerous dog. What is? How would you categorize Last National Bank? Do they have a security interest in the dog, and is it perfected?
I would say they don't yet.
Why not?
Because Just doesn't sound right, first of all. It just doesn't make sense. I don't know.
Well, I always tell you guys to go with your gut,
Yeah, it just doesn't
but
make
then verify it. Yeah.
If she has a security interest in the dog already, then, and like you said, that her security interest comes into play when they default payments.
Well, her security interest came into existence. It attached when the value was given. Right? She gave him the dog. It was right at that moment. I gave him the dog and signed this sales agreement. She had rights in the dog, so it attached when she sold the dog to the store. But at that point, when she sold the dog to the store gained ownership over that dog, and it became one of their items of equipment. And as soon as the store acquired that dog, it became subject to this floating lien that attaches to all equipment, whether existing or hereafter acquired. And there was a financing statement filed. So as soon as the dog's acquired, the bank, the PNC, LNB, the bank will have a perfected security interest in the dog. And Ms. Shaw only has an unperfected security interest. And so who would win, Taylor?
Because they have the perfected security interest.
Yeah, perfected security interest defeats the unperfected security interest. What should she have done if she really wanted to ensure that she gets the dog back? Because you remember, she's concerned about the dog having a good home. She's distraught now. She was really worried about the bank seizing the dog and selling it to God knows who.
Right. Couldn't she put some kind of provision?
What could she have done? I'm sorry, go ahead.
Couldn't she put some kind of provision in the sale or anything kind of like that kind of protects herself? Or I'm not.
No, I don't think so. It's not the direction I was going in. Let me give you a little hint, Taylor, and this is a difficult problem. So, don't be critical of yourself not nailing it. It is a tough problem. Okay. But let me give you a little hint. Now, she is selling the fang to the store, and she takes a security interest in that thing that she sold. She's a purchase money secured party. So she could, if she does the right thing, defeat the bank. But what do you have to do in order to get super priority over equipment?
You have to make it into a purchase money security interest.
Well, it is already a purchase money security interest, just the nature of the transaction, that she sold the dog on credit and took a security interest in it. That's a PMSI. She doesn't have to do anything more to attain PMSI status.
File a financing statement. Sorry.
You got to file a financing statement.
Sorry, I totally was overlooking it.
I know. Well, this is a lot. I mean, that's why it's a difficult problem, because it brings in, you got to understand floating liens. You got to classify this dog properly as collateral. You got to know the title reservation agreements are conditional sale agreements are nothing more than outright sale with the reservation of a security interest. And you have to know the purchase money secured security interest rules. So there's a lot here. And you can, if you get this problem, if any of you nailed this problem, my hat's off. But it is a challenging problem. But hopefully my explanation here has made sense. Yeah, if she wanted to really protect that dog, she should have filed a financing statement. And by when? Did she have a 20-day grace period, or did she have to file it before delivery?
It would have been before delivery at that point, right?
Exactly, because it's equipment.
Right.
So she had to, if she had been smart, she would have, executed the sales agreement and then held on to the dog until she was able to file a financing statement and then deliver the dog. I see Haley's hand. Yeah, I can't see Haley's. That's good. Yeah.
Can you hear me okay?
I can hear you too, yeah.
So I thought that inventory was when you had to do the notice before delivery, and that equipment was the 20-day. will to perfect. Do I have that backwards?
Nope, you got it.
So if this is equipment, it would be the 20-day rule.
Yeah, you caught me. You caught me in my error. You're absolutely right. Now the equipment you have 20 days for.
Okay.
Exactly right. Good going, Haley. I was just testing you guys. Yes, all right. So we have equipment here. So the rule for equipment is so it's the 20-day grace rule. So she had 20 days from delivery to file a financing statement. She should have filed within 20 days of delivery. That's what she should have done. Exactly right. Okay. So with that,
I have a question.
change,
Sorry.
but more questions. Yeah, I expect questions on this. I want them. I want to make sure it's all clear.
With that, she still didn't file within 20 days, correct?
Yeah,
Okay.
She didn't file at all, so she loses under these circumstances. But if she had wanted to win, and if she knew something about, Article 9, she should have filed a financing statement within 20 days of delivering the dog.
Okay, it's within 20 days of delivery.
20 days of delivery. Yeah.
Okay.
I have an administrative question while I'm here. Are we using the same code every time for this meeting? Like the same meeting ID? Is that what we're going to be using every time?
I thought you meant a UCC code.
No.
Like, yeah, they're using the same one. But yeah, the meeting, I think the link is the same and the meeting ID is the same. Yeah.
Okay, perfect. Thanks.
Yeah, that's another nice thing about Zoom. Okay. Please, one more question about this. I can't believe that you guys mastered all of this, but I shouldn't be surprised. You're a bright bunch. I'm sorry. I feel like my hair looks like Trey Gowdy. Like, it's not a great look. It is what it is. All right. Okay, then we're done with this problem. So no more questions. That's fine. Then it's 73. That was. Now we're skipping ahead, I think, a few problems to 76, and the Merchants Credit Association. Okay. Thank you, Taylor.
No
That was a tough one. Let's see. How about James? Are you there? Want to jump on the next one?
Yeah.
Awesome.
76. Do you guys hear me okay?
Yeah, I think so.
The Merchants Credit Association held a perfected security interest in the inventory of Harold's clothing store. Harold went to a fashion showing in New York and contracted to buy $4,000 worth of new clothes for resale. The seller was to Madame Belinda's Fashions Incorporated, which took a purchase money security interest in the clothes on December 10th, the date of the sale. Madame Belinda herself wrote the Merchants Credit Association on December 11th and informed the credit manager of the sale. He protested but did nothing. Belinda filed on December 11th. The goods were delivered to the store on December 12th. A, who has priority? I said Belinda had priority, basically because she followed the notice requirements of 9324B.
Mm-hmm. And the filing requirement?
Yeah.
Yeah, I think that's right. Assuming that, because remember, it says, the holder of the conflicting security interest has to receive notification. This is a little tight. She sent she wrote Merchants Credit Association on December 11th. And then she delivered on December 12th. It's not that you have to send notice before delivery. It has to be received. So we'll assume that it was received.
Yeah, I guess because he protested, so I guess they would have had to receive it.
I guess so. Yeah, I could read it like that. I don't know when he protested, but anyway, we'll assume that he received it before delivery. It was instantaneous, and you can notify people by email, and that's instantaneous. And then the next, right after the notice is sent, go ahead and file. So yeah, they filed prior to delivery and notified the holder of the conflicting security interest prior to delivery. You get super priority. That's right. Now, why? Let me think. Yeah, before we go on, just to understand why there is this difference. Why is equipment treated differently from inventory? Why? Why do we have to, with inventory, why don't we get a 20-day grace period? And it's for this reason. That the financial industry that makes its money by giving loans secured on inventory. These are inventory financiers. There are inventory financiers. There are accounts receivable financiers. Other types of financiers, but there are financiers that focus on making loans against inventory. Now that lobby during the drafting of the UCC said it's not enough for, it wouldn't work for us. It's not fair to give a 20-day grace period. We want to know before it even arrives. We want notification and perfection before it even arrives. We want, perfection by filing gives notice of a kind, but then there's actually written notice. We want both of those types of notice done before it's even delivered to the store. And why is that? It's because these lenders, say you're a bank and you're loaning money to so here, your Merchants Credit Association. You can just use these facts. Your Merchants Credit Association, and you're loaning money to this clothing store, and you're making loans depending on how much inventory they have. That's your collateral. So you're only going to make them a loan if you know that they have sufficient inventory, serve as collateral. So what these inventory financiers were worried about is that the clothing store here might receive all this new inventory, these beautiful gowns from Madame Belinda, and the inventory financier, Merchants Bank, might say, hey, look at all this great new inventory you have. Yeah, we'll loan you all this new money against it. That's great. And then they find out, then they receive, they don't receive notice, let's say under the equipment rule, they would never have received notice, and only later found out that, hey, that's a purchase money, that was a purchase money security interest, and they lose against that party. And they'd be very unhappy about that. So inventory financiers want to know beforehand whether their debtor is receiving inventory that's subject to a PMSI, because then they'll know, hey, the PMSI, the PMSP is going to get that inventory. We're not going to get it. So we're not going to loan any money against this new inventory because it's not going to be our collateral. So that's why the rule is different. The banks that extend loans based on equipment, they didn't demand or get this special protection. They're allowed this grace period. So if you're lending against equipment, you do have to be careful, because there might be equipment on the floor of this factory that's subject to a purchase money security interest, and you're not going to get it, even though you perfected long ago. So you have to be careful with that with respect to equipment. But with respect to inventory, you don't have to worry about it. If any inventory is subject to a PMSI, you would have gotten notification. So that's kind of the history behind it, and the reason for it. The reasons, all of this stuff, is there any complexities in the law? There's a reason for it. And typically, it's due to Washington lobbyists. Okay. Carry on, James. I didn't mean to take that away from you.
And then
Done well.
Part B just changes when if notice was received after delivery, and that would change the answer to priority because they wouldn't comply with the notice requirements. So,
Yep, that's right.
and then Part C, if notice was received on December 11th as above, is it sufficient to permit Belinda to keep selling goods to Harold for an indefinite period thereafter, or only a one-time transaction? I figured it'd probably be a one-time transaction, and then after what you just discussed, it sounds like an indefinite period would be inappropriate for inventory.
Yeah. Well, an indefinite period isn't possible. You have to. It only lasts for 5 years. If you give notice, it'll only last for 5 years. But when she sends notice, will it even last for 5 years, or will it only? Will she only have her super priority with respect to this one shipment of gowns? Or and if she decides to send more, in a month, does she have to send out new notice, or will that notice suffice to cover the second shipment?
It says that you also have to describe the inventory, so I imagine the notice would have to describe everything. So I guess something that's not contemplated wouldn't be covered.
Yeah, that's a good way to put it. Yeah, the notice can be good for up to 5 years and can ensure that you have your super priority with respect to future deliveries as well, but only if you say so in your notice. I mean, here, what does it say? That the notice, all it says is she informed the credit manager of the sale. So it sounds like she only notified the secured party of this one sale and this one shipment. In that case, she would have to send out another notice for future shipments. But if in the notice she said, I will be selling gowns now and for the indefinite future to this boutique, then that notice would be sufficient to ensure super priority for the subsequent shipments, but only for 5 years. Any questions? Good job with that, James. Any thoughts?
Yeah.
Yeah, I have put you guys on the gallery mode now, so you can raise your hand. I see now that does work, so I can check that off my list. I figured it out. Good. How are we doing with time here? Oh, it's 12 already. Look at that. We're done. Wow, that went fast. That was so much fun. All right, well, let's just end there, and we will continue. I think we have one more problem in this this assignment for Wednesday, and then let me see where we are, 67. Yep, and then we're going on to control and priority. So the next assignment, we're going to get into deposit accounts and investment property to some degree, but not too deeply, because that gets quickly very complicated when you're talking about stocks and bonds, uncertificated, certificated securities, et cetera. But we'll deal with it to some extent. So yeah, let's plan on finishing up assignment 9 and doing assignment 10 on Wednesday. But the first thing we'll do on Wednesday is go through the midterm. And I'm going to end the meeting now. Wish you all well. Ask you all to stay safe, maintain social distancing, wash your hands, and I will send your midterm scores out right now. And again, as a group, you all did really well, and we'll go over it on Wednesday. And good to see you all, and I'll see you soon. Ciao. Bye-bye.